Richard Allen was convicted of killing Abigail Williams and Liberty German. He was sentenced to 130 years in prison. Now, the appellant's brief has been filed, as well as the appellee's brief. We're going to go through the whole process of debating it tonight for you with three of the smartest lawyers I know. It's bound to be a good one. Stay tuned. All right, welcome to Defense Diaries. I'm your host, and as always, I am joined by my beautiful and brilliant co-host, Allie. What's up, girl? You're muted. Wow.
Hey, babe. Hey, all.
Hey, good job. Good job.
Hi, Andrea.
And,
hey, girl.
And we are joined by another beautiful and brilliant attorney, Andrea Burkhart. Thank you so much, Andrea, for being with us. We really appreciate it.
Good to be back.
Yeah, I'm really excited about this. I kind of came up with the concept yesterday, and I was tinkering with it because I set this live, and we're waiting for Ausbrook. He warned me ahead of time he was going to be a 6:15 start time. But before we get into the rules of engagement, the reason that I wanted to do this, and I want to hear from both of you guys as well, my feeling on it was, look, we've got two very divided sides here. We've got two briefs that need to be addressed. We are obviously, I think it's safe to say, all three of us believe that Richard Allen is factually innocent. So I'm biased in that sense, and I'm not going to hide that fact. But I think it's equally important for us, even though we feel a certain way about the case, to talk about the briefs with some intellectual honesty. And I think that the only way we can do that is do it in the format that we're going to do it, which is to have one person, Michael Ausbrook, who's a brilliant post-conviction lawyer, who was also worked for the AG's office. So he's been on that side of the aisle in his career. So I thought nobody better to do it than Michael, and he's got incredibly thick skin. So, you know, he'll be able to take all the abuse that he'll probably be getting. And just know Michael's position has not changed in real life. For the purposes of this exercise, he is playing the state of Indiana. He does not feel that Richard Allen deserves to be in prison. It's quite the opposite. So, I mean, what do you guys think of the approach? Why do you think it's important we do it this way?
Well, I really was excited about your idea of handling the appeal in this kind of issue, in this kind of format, because we do have two very different perspectives on not just the case itself, but the law and the process, and kind of what it is that we're doing here. And so this case, I think in many ways, provides a really good jumping off point for getting to understand just through the appellate framework, how these things get balanced out. It seems very simple from a lay perspective to just look at, well, but what's the evidence and what are the facts? Like, what happened? What's the truth of the situation? And if you were not a lawyer, you might think that might drive the train like 100% of the time, getting things factually correct and getting, factual justice in that sense. But the reality of the law is quite different. It's got a 10,000-foot view that is much more procedure focused, less concerned about what is the outcome to any one particular individual, and more about how does the system as a whole need to be structured in order to function the way that we need it to function to have a justice system at all. So there's always a lot of these competing considerations and values and things of importance that the different sides are going to emphasize depending on how it benefits them in their particular situation. In this case, I think we have extremely strong facts on the part of Richard Allen. We have very strong law and process on the part of the state. And so how that's going to get reconciled is really what the appeal is all about.
Yep, 100%. Do you have any other thoughts, babe?
I just want to ask before Michael gets here and we put on these hats that we're wearing tonight. I just want to ask Andrea what she thinks about now. For all of you out there, I'm sure some of you may know some stuff that is in the state's response. Some of you may not. So I guess just follow along here. But as far as the waiver issue, why do you think appellate counsel, who, for everyone out there, they know whether or not someone objected at trial? It's like, I mean, tell me if it's not the first thing you do before you go to raise an issue is go to the transcript to see, is it preserved? Did somebody object? Like that kind of thing. Why would they lead with an issue that is, at least, unless I'm missing something, because not only did they not object, they said no objection is completely waived for the purposes of a appeal.
So for as far as like why you would potentially raise that issue in the first place, I mean, there are exceptions to it. There is something of a strategic decision in all of this, because if there is an exception, you can argue it. If there is facts in the record, you can argue that. The question is really, should you anticipate the state's argument in your own appellant's brief when you're deciding, you know, both what issues am I presenting and the order I'm presenting them in, and so forth, to try to put yourself in the best possible footing. And so I think we're going to somewhat unsatisfying answer is that we're going to see, you know, how they deal with it when we get their reply. And so we don't necessarily know kind of what their strategy, what cards they're holding on these particular issues are. Sometimes it can be favorable if you don't think it's a particularly strong issue, or at least you want to play it as if, like the waiver argument is not particularly strong, then it can be fine to treat it just sort of dismissively. And if you're actually going to argue this, then okay, fine, I will dedicate some time in my reply to address it. But you can potentially minimize it if it doesn't seem all that strong in that respect. They do have, of course, the space limits, and so the page limits and everything. And so that can be a factor in sorting out, what do I raise as, you know, in anticipatory fashion versus what do I hold to bring in my reply when I have more space. And part of it can just be the overall tone and tenor of your appeal. And I think in this particular case, again, it's one where just the facts and the real injustice and the serious questions of what happened here are either going to grab you and get you to care about it, or they aren't. And if they aren't, then I'm just not sure there's going to be an awful lot in the law that's going to get you, you know, real excited about a different kind of outcome than just understanding the big picture of what actually happened to Richard Ellen and what this case is actually based on, and what really does undergird this theory that Richard Ellen is bridge guy and committed these murders and so forth. And so if your theory kind of requires you to abandon, you know, some of those fundamental points about how this injustice was perpetrated, then you just, I guess, got to kind of reconsider if the weakness of an issue that is kind of critical to making the bigger point of what your case is about, you know, it may be worth including just for that reason, even if it's not necessarily going to be a knock it out of the park winner, you know, from an appeal standpoint. If it's going to help you potentially get the court's attention and see the case the way you want them to see the case, then you bring it up, even if you don't necessarily have a real clear and black and white legal pathway to get to the outcome you want. But what do you think about it, Ali? What's your kind of knee-jerk reaction to that first issue?
Well, on the Franks, I was just like, wow, it really is. If they said we have no objection to every item that was found pursuant to the search, then the Franks issue is dead. I mean, I guess I see your point that by putting in the Franks issue, they can show how disingenuous, how misleading, how, you know, full of shit the state was in the lower proceedings. Right. It is a pattern.
This is a pattern.
And when during our, you know, official, what's this debate? I'm gonna, you know, answer. I'm assuming you've got some Frank's questions, and even though I think the issue on anything where they specifically said I have no objection, and where they didn't. So on the I do think on the confessions there's room, because they did object and renewed their objection, and then just didn't put in a continuing objection. So I think there's room to say that issue is not 100% like gone. Like, oh, you waive this, and we're busy over here at the appellate court, so I'm not gonna just decide to look it over. But yeah, a pattern exists, and it's demonstrated even in their response. Just their overstating of their hand is just, it's, to me, like ridiculous. But there were,
I think,
there
you
was
know,
something I
that's
wanted to ask you though, but go ahead, say what you're going to say, and then I'll ask you.
well, I was just going to say, I think that's one of the weaknesses about making these types of procedural arguments, and making them such a heavy focus of the opposition to the case is, one, it makes it more obvious that you can't fight on the merits, so you have to complain about how we went about it. But there's a lot of room with these types of issues, I think, to always go back and argue the policy. Like, why do we have these rules in the first place? These rules are designed to prevent sandbagging. It's to avoid creating an incentive where that there's an issue and you just deliberately don't bring it up. So you get like your free trial, and then come up with it on appeal for the first time. This is an abuse of the process. It makes things inefficient, and it's just another way of not playing fair. How does this situation, where you filed a motion ahead of time and you've asked for a hearing, and because the court didn't give you a hearing, you were never able to flesh out the factual basis to be able to substantiate the argument one way or another? How does that really further this policy, this waiver policy of it's not like nobody knew this was an issue. You filed a motion and you raised it. So you can always, there's always at least a little bit of room to kind of hook the court in the cares. If the court cares, they can find a pathway to a lot of different things.
Yeah.
But if the court doesn't care, then that's where you're kind of stuck, no matter how much you have in your favor or not. And so this is a situation where if the court cares about the facts, and the court cares about the potential that there has been a serious injustice that's been done here, they don't have to apply hyper technical applications of the rules. They can almost always find factual exceptions around. They can find language from some obscure case somewhere in dicta that says, here's what we think it should be, and so forth. So there's often pathways to get there. The real challenge on appeal is getting them to see the necessity for it and to want to correct the problem. So if you can accomplish that, the rest of the detail is often just kind of loss-smithing.
Right. And
All
I know
right.
you're about to bring Michael on, but then I have to ask Andrea a question before we get into the official debate.
Okay. Michael, his camera's not on. I don't know if he's ready to come on yet, but he is backstage. Okay, good. There he is. I'm bringing him in. Michael Ausbrook, welcome, my friend. I'm thrilled that you are here.
Hi there.
All right, so you're wearing the white hat tonight. So prepare yourself for it, my friend.
They should start calling that the black hat. Go ahead, Michael.
Well, I was thinking of that, and it's been 30 years since I wore that hat.
Yeah. Well, is it like riding a bike? That's the $1 million question.
It is easier than riding a bike.
All right, good.
All you have to ask is, and then what happens?
All right.
Or
Here,
wait.
what I'm going to do now. Oh, go ahead.
Yeah, let me ask.
Short on time because
I know. Real quick. So, because you were there, and this is what I thought. I thought the defense re-raised Perlmutter again after the whole opening of the door, the undoing. There's no mention in the brief, but I thought in court they did bring that up again. Did that not happen at trial?
So
I vaguely remember that it did, but yeah,
let,
I don't.
let me interrupt. I texted you, Allie, about where Perlmutter was preserved. It's in volume 14, I think.
Oh, good.
I sent you a screenshot.
That's true. I saw it. All right.
Okay.
So
Shoo.
I'm gonna start with the rules of engagement here. I'm gonna kind of whip through these because, as I said, Andrea's got a drop dead time when she's got to get off. So I'm gonna try to get through as much of this as we can. If we can't get through more than half of it, I'm gonna probably bug both of you to come and finish it on a different date. But we'll do the best that we can. All right. So this is the way that this is going to go, everybody. This is a structured adversarial panel. Each side represents a position and must defend it against direct challenge from me, the moderator, and the opposing side. This is not a roundtable discussion. This is a debate. I will be acting as the moderator. I control the floor at all times. No attorney is going to speak unless recognized by me, the moderator, me, may cut off any speaker who exceeds time, goes off topic, or refuses to answer the question directly. So,
What if I bat my eyelashes? Can I get more time?
probably,
Okay.
I'll probably cave. Michael Ausbrook, my esteemed colleague and friend, will be representing the state of Indiana here. He's going to argue the position of the state of Indiana as presented in the appellate brief. He's going to defend the conviction, the trial court's rulings, which I know is going to really kill him inside, and the state's legal theories. Andrea Burkhart and Allison Motta will be arguing the position of Richard Allen as presented in the appellant's brief, attack the conviction, the trial court's rulings, and the state's legal theories. Allie and Andrea may divide questions between them or both respond, but their combined time per question must not exceed the allotted clock, which you can see right there in the middle. So the time allocation is going to go as such. After I ask a question to one side, that side has 5 minutes to deliver their answer. The clock starts when the attorney starts speaking. Now, typically this is how it'll play out. I'll ask one side a question. At that point, whoever it's addressed to will start answering. I will start the clock. You will have 5 minutes. You do not have to use all your allotted time. If you answer a question in 2 minutes, so be it. Then we will have a rebuttal for either side. Either side can either pass on the rebuttal if they don't want to rebut it, or if you do, I'm going to switch to the 2-minute timer for a rebuttal. I was originally going to have a surrebuttal. I had to ace that because of time constraints, and that is basically. Do you guys understand the rules?
So if, for example, in the 2 minutes, I can say, I'll yield my time to Michael and he can use the last of my.
Well, why would you yield it to the?
I don't know, like just in case.
You could yield it to your partner there.
Well, I'm definitely gonna, yeah.
You could say, and you guys are gonna have to figure out which one of the two that you wants to answer the question, or you guys can split time, or you could say, make some kind of hand signal like, "Hey, save me a minute."
I like wave if I'm dying to say something.
There you go. Perfect. All right. So these are the rules of conduct. The attorneys must answer the question that I ask. Pivoting, filibustering, or redirecting.
No filibustering.
No filibustering. Redirecting to a different topic is not permitted. I will redirect. That's not what I asked. Let me repeat the question. Stay in your lane. Michael argues the state. Allie and Andrea argue Allen's position. No attorney may break character to editorialize from a neutral position. If you think your side has a weak point, you still defend it. That's advocacy. All right. So here's the bottom line. I was going to have opening statements. We're skipping those. And as far as the audience goes, the way that we're going to do this, I am not the judge. I am merely the moderator. You guys in chat, you're the judge. At the end,
Michael doesn't have a chance with the hard chat.
Well, you never know. You never know who's in the chance. You never know. You never know who's in the chat. So, but this is the only rule that matters. Bring your A game. The audience is watching. The briefs are public. And somewhere in Indiana, a man is serving 130 years. Actually, in Oklahoma, a man is serving 130 years based on confessions he made, while the state says he was gravely disabled. This debate matters. Treat it that way. All right. So. Without further ado, let me get this thing up and running. All right, so we are about to start. Is everybody ready?
Yep.
Okay, Michael, the first question is to you. Okay, and it is that the state's brief leads with waiver on virtually every issue. Can you walk us through that strategy? Is the state telling this court or the court that it doesn't even need to reach the merits? And if so, why spend 90 pages arguing the merits anyway?
Because that's just how these arguments go. You start with waiver, and so that the court won't even get to the issue. And then you use the expression, even if. And even if it wasn't waived, you lose on the merits. And then you discuss the merits, both the factual part of them and then the prejudice part of them. And you do another even if. You say, on the merits, there was no error here, but even if there was, the error was harmless under whatever's the harmlessness standard is for that particular issue.
Okay. All right. That was a good use of your time, sir. I appreciate that.
But does that mean I get it? Do I get my 418 back for?
No, it's lost. It's lost forever. All right. Okay, ladies, rebuttal.
Well, I will just rebut briefly to not really meaningfully contest anything that Mr. Ausbrook has said. I think that's exactly what you do. If the argument is arguably present, then you have a strategic decision whether you're going to raise it or not. And it's rare that a prosecutor will not raise an issue like waiver or non-preservation of an issue or something like that, because it is effectively a free win on procedure without having to get into the difficult questions of whether the outcome is really warranted or not. I think the challenge from a strategic standpoint is there's always lots of exceptions to waiver. There's no exception here in Indiana. There is an exception for the fundamental injustice. I think it is a fundamental error exception to waiver that I expect the defense is going to argue in this case. But also, it just does run the risk of making your whole approach to the case look a little too cute by half, look a little too over technical, a little unconcerned about whether you're actually achieving substantial justice or not. And so if you have a bench that isn't particularly captivated by the facts or the questions that the issues present, then that won't harm you. But the risk is that if you do have judges that have questions and concerns about the case, then an overemphasis on procedural defects can come across as a bit empty and unsatisfying.
Well done. Well done. Thank you. All right. This question is addressed to you.
I don't get any. I don't get any.
No, sir. Rebuttal.
Wait,
No,
there's extra
That's not
time. Let him
rebuttal.
use it.
all right. It's okay.
Andrea's was a reply. I get a rebuttal.
Yes. All right. Go ahead.
No, I mean, you can make that one.
You go.
And I just want to say, at least Indiana courts, fundamental error isn't going to fly with any issue in this case. It's usually applied to instructions. Occasionally there's a thing called an evidentiary harpoon in Indiana, which is kind of like fundamental error, where the state puts on stuff it shouldn't have, knew it shouldn't have. But there's nothing like this in this case. The other thing is, I have never seen, you probably wouldn't see it, but at least the Indiana Court of Appeals they don't overlook waiver. They just don't. What they will do is they'll say it's waived, and then they'll say, but even on the merits, you lose. And they do that probably to save time on the ineffective assistance claim coming later in the post-conviction case.
All right. Very good. Okay. Now we have a question addressed to Allie and Andrea. The state says that Allen's team affirmatively waived both the search warrant challenge and the confession challenge by saying no objection at trial. That's a real problem, isn't it? How does the reply get past that?
Well, I can start on that first. I do recognize that Indiana law, a defendant must, even despite pretrial motions, must contemporaneously object at trial when the challenged evidence is offered. And and if a defendant affirmatively states no objection, that the evidence at trial may not challenge its admissibility on appeal under, I think that's the Halliburton case. However, on the confessions, okay, now on the search warrants, I'm taking it at face value until we see the response that there was a no objection. But on the confessions, I think there is room, and I'm anxious to hear Michael's reply, because before the testimony began on the witnesses talking about the recorded statements of Allen, they did renew the suppression objection on the record, or the exclusion objection on the record. So before testimony began, there was extensive pretrial briefing and hearings in context where the trial court had a full opportunity to rule. I would suggest and request of the court in reply that that all of that cannot be nullified by a subsequent no objection statement to specific evidence within the category covered by the renewal. The natural reading of no objection to specific exhibits after a general objection has been renewed on the record is that counsel is not raising additional objections beyond that already preserved. Now, look, should counsel say that? Just the words, no additional objections? Sure. But I think the argument can be made that that was not counsel affirmatively withdrawing the renewed suppression challenge that he literally just made right before the witnesses took the stand. And I'd argue that that reading is consistent with the purpose of the preservation requirement, which is to give the trial court an opportunity to correct errors. That opportunity was ample here, provided through the pretrial proceedings and the trial level renewal. And I think that for those reasons, the confession issue is sufficiently preserved for review. What do you think, Andrea?
Yep, Andrea, you have 2 minutes and 30 seconds left. Would you like to add to that?
Yeah, well, I would add just that at least I'm certainly not the expert in Indiana law that Mr. Ausbrook is, but just in terms of the way that the issue has been framed and the cases that have been cited to support the argument for waiver on the Franks issue, primarily the Brown case, does, again, it recognizes this fundamental error exception, and it may be that subsequent case law has kind of ratcheted down on what that actually means, but at least in terms of the language of Brown itself, it contemplates that that includes blatant violations of basic and elementary principles of due process. And the due process violation is really at the heart of what you're getting at with the Franks argument. This is a argument of misconduct on the part of the state by, deliberately misleading a magistrate, either by purposefully including false information or failing to include information that is exculpatory and would likely change the probable cause analysis. So I see a potential pathway to make that argument, although certainly, as Mr. Ausbrook has pointed out, there may be more specific case law in Indiana on how this particular exception applies here. But further, just that, as Ali has kind of pointed out, it doesn't support the purpose of having these waiver rules in the first place. The idea is that you're not supposed to sit back, ignore an error, and get your free shot at acquittal, and then bring it up for the first time on appeal. This is clearly not that. It doesn't further that. And the problem here is that the error itself isn't even able to be litigated because of the fact that the request for hearing just simply was flat denied. So there's no record developed to be able to evaluate the extent to which, Mr. Liggett's statements were ill-motivated, or what he really knew at the time, and so on and so forth, which the state argues in their brief is kind of the justification, the no harm, no foul kind of argument on this. So ultimately, the real issue here is that they should have had the Franks hearing in the first place, and we wouldn't have to be debating whether there's a merits decision that was waived or not.
She's on
Excellent.
point.
Michael Ausbrook, reply.
You're muted, Michael. You're muted.
Let me pause the clock. I'm going to restart the clock. All right.
Whatever.
Reply.
So on the Franks and waiver, I don't think it is a due process problem. It is a Fourth Amendment problem. And the reason it is not about, Franks is not about fair trials. The Fourth Amendment is not about fair trials. It's about deterring police misconduct. And there may have been police misconduct, but you'd have to look for the exact page number. But, one of the major things that was the result of the search warrant was Mr. Allen's gun. Mr. Allen's gun was exhibit number 276. It's in volume 9, I believe. And specifically when that's offered into evidence, I think it is Mr. Baldwin who says, no objection.
Right.
And without the gun, you don't have Melissa Oberg. Obviously, it's important, but I don't think, I don't know of a case, and you can find an Indiana Court of Appeals case to say almost anything you want, but I don't know of a case in which someone's blown a Fourth Amendment issue, waived it, and then the court has stepped in and said, oh, fundamental error. Now, I've got 25 seconds on the confessions. I think the major argument on the confessions is that even if they're not waived, I think they are, but the arguments aren't waived. The argument there's coercion. I think the argument on coercion loses, and I think any argument on voluntariness is waived.
All right. Thank you, sir. All right. Mr. Ausbrook, this is to you. The state argues that it isn't even eligible for fundamental error review on the search warrant because Allen claims reckless conduct, not willful malfeasance. But doesn't lying twice about the blue jacket, if that's what happened, look pretty willful?
So I would go to the standard I think it's irrelevant whether it was willful or reckless. I don't know what case the state actually cites. My argument for the state would be that if you set aside what they're saying, what Mr. Allen's lawyers are saying is false, and you include what they say is omitted, there's still probable cause.
Okay. Reply.
Not me.
Yeah, so I found this argument on the part of the state to be a little bit imaginative. I mean, it's not particularly well cited. It's an explanation that the state has come up with for why they think that this wouldn't constitute some kind of serious state misconduct. I think the problem is that, number one, again, there's no findings on any of this to review. This isn't a situation where we had a hearing and we took evidence and the trial court made findings based on that and then concluded this is admissible or not admissible based on those findings. So we don't have anything to review from which we would be able to say what Mr. Liggett's intentions were or his thought process or anything like that. And that's precisely why there needed to be a Franks hearing on this in the first place. But I think kind of related to that is, I I would push back first, I guess, that this is a pure Fourth Amendment issue because Franks itself puts it in terms of Fourth and 14th Amendments. Anytime you're talking about police malfeasance and particularly capitalizing on it to obtain a criminal conviction, we are potentially now getting into due process arena. We're talking about conduct that potentially shocks the conscience. So ultimately, the argument comes down to, if you just look at the facts the way that we continue to argue the facts need to be interpreted, by disregarding some of the fundamental problems with the evidence and some of the conflicts that have never really been explained and just continue to be talked around, like how, Rick Allen doesn't match the sketch and the descriptions and so forth, then you get to harmless error. But it's only by adopting the cherry-picked view of the case that the state has to present in the first place that you get there.
Mr. Ausbrook, I would give you 1 minute for a reply. Would you like that?
Well, Ms. Burkhart may know Franks better than I, but I think the mention in Franks of the 14th Amendment is simply the incorporation of the Fourth Amendment through the 14th Amendment. And perhaps I'm wrong, and there is a discussion in there, but I think Franks is again, it's a pure deterrence case. The way and I don't think that the Indiana Court of Appeals actually can look through the waiver once it's argued by the state.
Okay. Thank you, sir. All right. This question is to Allie and Andrea. Let's talk about what Detective Liggett actually put in the affidavit versus what he left out. The state says that Carbaugh corrected her description in later interviews, so Liggett's representation was accurate. How do you respond to a court that says, quote, that the affiant used the most recent information from the witness? What's wrong with that?
Can I start, Andrea?
Please.
So the state says, okay, that Carbaugh used the word bloody in her second and third interviews, and even said the man, quote, looked like a slaughtered pig. Allen does not dispute this point, but points out Liggett's affidavit specifically attributed those words to, quote, an interview done of Sarah Carbaugh in 2017, the first interview, when in fact, in that first 2017 interview, she described the man only, as we know, muddy and wearing a tan coat. Obviously a meaningful distinction. Liggett cited the earlier interview by year, but supplied a description from later interviews, creating the impression of a single consistent account. The state's response that Liggett may have not remembered which interview contained detail given in the 5-year span, that's them trying to lay the groundwork for a legitimate innocent making argument. But innocent mistake argument, but innocent mistake and deliberate falsehoods, those aren't the only two options. The Frank standard reaches reckless disregard for the truth, attributing later interviews descriptions to the first interview under circumstances where the first interview was the only one described as occurring, quote, in 2017, at minimum raises the question of recklessness, and the state doesn't adequately address that distinction. And there's more than just that. I mean, there is a pattern demonstrated throughout the affidavit that I would argue is contained within their reply of overstating their evidence, acting like things are more concrete than they are. They do it with Allen's timeline. Talk about something circular as hell. Okay, they argue, and Bob or moderator, you have to tell me if this is like another question, and then I'll stop talking about it. But when they talk about saying, all right, we don't need, or should I not bring up Blair right now?
Well, I mean, I think wait, hold off.
Okay.
I think we're going to address it. Okay, Andrew, you've got 2 minutes, 36 seconds. You want to use any of it?
Yeah, I think the issue here is that as the state themselves points out in their brief, the probable cause determination is a totality of the circumstances test, and so the problem here, the state is rather cutely accusing the defense of cherry picking what information Sarah Carbaugh provided from the one interview versus the three. But of course, the reason why Mr. Allen has to do that in the first place is because that is what Mr. Liggett did in preparing his search warrant. He conflated all three of these searches into one, and he didn't present the totality of the circumstances, which is a changing story that evolves over time with different questioning in response to different requests. So that context speaks to the veracity and the reliability of that statement. The fact that it was, not the initial recollection that she had or that she recounted. These things factor into the likelihood that what she is reporting is actually truthful information. And so, is the fact that this person only eventually came up with this version of events, is that something that you would want to know if you're being asked to decide if the person she identified probably committed a crime? Yeah, I tend to think that is particularly helpful information. So for me, that's the primary issue with it, is that no, it doesn't. It's not like actually making something up, but it's just omitting critical context that's necessary to be able to give that particular statement the weight that it deserves.
Okay, 1 minute for reply.
Oh, down to 1
What
minute.
happened is 2 minutes.
Okay.
I was robbed.
Right.
I think so again, there was no objection. So the Franks is all about whether the search violated the Fourth Amendment. And the evidence wasn't objected to. So waiver again, but waiver aside, you had Betsy Blair identifying from the picture whatever her description was, identifying the person she saw as the picture of Bridge Guy. And the magistrate, Diener in this case, the judge, for himself could see that Bridge Guy possibly looks like a little like Rick Allen. That would be probable cause is the third lowest standard in the law. The lowest is the scintilla of evidence standard. The next is reasonable suspicion, and those are really low. And then probable cause is just reason to think maybe. I'll stop there.
Okay. Now, ladies, you get 1 minute for a reply if you elect to use it.
The problem is that even if it's a low standard, it still has to be based on evidence that is accurately stated and given some weight by the magistrate, who, granted, has some discretion to decide how much. But I think the problem here is that we have the description, the argument that her description of the physical traits of Bridge Guy and the sketch and everything isn't really important because she identified the sketch and there's enough there to conclude that it's Richard Allen. Ultimately, because according to the state, Richard Allen put himself there anyway, but that's based on misrepresentations of the facts in the record. The timeline in particular, that he put himself there at a specific time, ironically, the same thing that the state is now accusing Richard Allen of doing, of cherry picking a single statement out of many, is exactly what the state has to do in order to maintain this timeline, because Richard Allen did not, during his recorded interviews, put himself on the bridge at the time that they claim he was there. He also did not report seeing the same number of girls that reported seeing Bridge Guy, that they're trying to put as the same person. And then we have the problem with the car as well. Two people seeing a car, but describing very different cars at about the same place, at about the same time. And no effort to try to reconcile that as a coherent reason to believe that Richard Allen is guilty.
Okay, thank you. Okay, so that was a beautiful dovetail into my next question, which is addressed to Michael Ausbrook. The state's strongest argument on probable cause is that Allen was essentially his own worst enemy. He placed himself on the trail, on the platform, at the right times, according to the state, and said that he saw no one else. But here's my question. If Allen's self-placement is sufficient for probable cause, why did Liggett need to include Blair and Carbaugh's description at all? And if he included them, didn't he have an obligation to include them accurately?
Well, as the state's brief says, he did on one view include those statements accurately, and the answer is no, he didn't have to include Blair and Carbaugh. He thought that they were more evidence. Just being on the bridge and not seeing anybody may not be enough, but it turns out that we won't know if that was enough until the Court of Appeals decides things. But in any event, in light of the confessions, all of this is harmless. I mean, you've got waiver on the front. You've got waiver on the front end. You've got waiver on the front end of the Franks memo, and then you've got harmlessness on the other. As Justice Scalia said in an opinion, confessions are the queen of evidence. And you know, your question started with Rick Allen being his own worst enemy. Well, yeah, they're the confessions.
Okay. Response?
Well, I think it's outrageous circular reasoning. First of all, the state's trying to argue that even correcting all the challenge statement and omission, probable cause survives because Allen's own self-placement at the scene provides independent foundation. This argument requires you take serious logical leaps and ignore that it is not as the state says. The state's probable cause arguments runs Allen placed himself at the trail during a broad window, right? It's between, according to them, 1:30 and 3:30, not from 1:30 to 3:30. Okay, Blair saw Bridge Guy on the first platform around 2:13. Allen's presence on the trail overlaps with the Blair sighting. Allen was there for probably the platform at the murder at the relevant times. Allen is there for probably Bridge Guy. And then they tried to say, we don't need Blair to accomplish this. However, you just use Blair, even in your logic that Allen places himself there, which Allen doesn't do in the way that the state puts out there, but they're still tying it temporally to the person Blair saw, when in my opinion the facts establish that Blair's description of who she saw forecloses it being Richard Allen.
Andrea, do you want to chime in?
No, go ahead.
Reply. Or I'm sorry, yeah, reply. 1 minute.
So but see, Blair's description on the one hand may contradict her identification, but she was she was absolutely certain when shown the picture of Bridge Guy, that is whom she saw on the platform, whatever her description was. And she testified to that at trial. So one can assume that her testimony would be the same at a Franks hearing.
Mr. Ausbrook, let me ask you this. Even if, assuming arguendo, that they did strip the rest of, say, Blair and Carbaugh isn't in the affidavit for warrant, is it your argument that there's still enough there for probable cause?
Yes. He's there. He, even without, he puts himself there at approximately the right time. He doesn't see anybody else. And even without Betsy Blair's identification, a magistrate can see that Rick Allen does look somewhat, at least, like the photograph of Bridge Guy that was publicly available at the time. It's enough for a search warrant.
Okay. Thank you, sir. All right. Allie and Andrea. So the state makes a powerful point that Blair's description is secondary because Allen himself supplied the nexus to the Bridge Guy, or supplied nexus to the Bridge Guy. So how do you get around the fact that Allen literally told police that he was on the platform at the same time that Blair saw the Bridge Guy there?
Well, he didn't, sir. That's not what he said. And that's the problem with, and I know you're playing your moderator role, so I'm staying in character as well. That's absolutely incorrect. Again, he gave a range. According to what they wrote in the first interview, it was maybe between 1:30 and 3, or 1 and 3, whichever it was. And I have always taken that to mean that's different than from. He's not saying he was there from 1:30 to 3. So he is describing a large window of time during which he was out. If he did, in fact, say he was out on the platform, I'd have to go back and listen to his statement. I know that was like a thing that came up. I'm just not 100% sure it's what he said, but I remember the questioning by his wife. Like, he didn't tell me you were, I didn't know if it was on the bridge or on the platform. That's where but let's assume he said on the platform. He clearly wasn't there when Carbaugh looked, because Carbaugh saw someone who, by all definition, cannot be him. Moreover, all of the other facts they use to place him there, to tie him there, are what we call in the biz bullshit. You have to accept, first of all, there is a difference between who the people saw. You have a group of 3 people saying, or was it 4 people saying they saw Bridge Guy. You have Allen saying he saw 3 people. This is not an empty trail. This is a window in the day. You have to go back and bring up Cheyenne Mill. I reread her testimony today. She is around 2:00 or so. She is on the platform. Her and her friend cross the bridge. They are going to the bathroom on the other side of the bridge. They are looking around to see if there are people there. Okay, so, and I guess I'm going too far afield on that, but everything requires you to accept the state's proposition is true. Oh, he parked where they saw a car. First of all, he never said he parked there. So the state just keeps insisting he parked where there was only one car. So even though all the witnesses said they saw a car that was, again, just like Blair's person on the platform, concretely not his, absolutely positively not his, they say that that's where he parked. Then they say because he crossed 3 people who he didn't talk to, and 4 people crossed Bridge Guy's path and Bridge Guy didn't talk to them, is absurd. Every single person who spoke, including Cheyenne Mill, who the people she crossed were absolutely, it was like 2 people and then 1 person, none of which looked anything like Bridge Guy or Richard Allen. Those people, guess what? Didn't talk to her. They didn't talk to her. And Blair, the bloody, muddy, crazed man, didn't talk to her. People are walking. They're not stopping. And, yes, some people are friendly. They smile at everyone who passes them by. But here, every single person who had said something has said, the person who passed me didn't talk to me. So, and I'm sorry, I'm not looking at my time because I was reading where I wrote that thing about Cheyenne. Okay. So I just think you cannot accept their timeline. And when they state it so affirmatively, like that's absolutely, look, I think even for probable cause, by that they're overstating their hand on him putting himself on the timeline. I understand the state's point by Mr. Ausbrook that, look, you're talking about probable cause. So you've got a man who looks a lot like the person in the video around the time, but you have all these other factors that I think speak to it being absolutely somebody else that the state is trying to whitewash.
Andrea, chime in.
Sorry,
The problem with the timeline and the insistence that the timeline kind of cures all ills because Richard Allen put himself there with the timeline is that it all depends on bootstrapping a lot of other implications that the state wants to make but can't establish. It all depends on Sarah Carbach and Betsy Blair and not Cheyenne, but the other girl on the trail.
Really, Voorhees.
Yeah, Rayleigh Voorhees, all reporting the same individual. That necessitates a time frame, and the inconsistencies between who they describe and their inability to tie that person to Richard Allen is in and of itself a pretty good indicator that the person they saw was not, in fact, Richard Allen. It necessitates this conclusion that Bridge Guy equals Richard Allen because of the timeline. But that's because you're presupposing the timeline when we have ample reason to think the timeline is simply wrong. Richard Allen clarified his time frame during his subsequent interviews, and his identification of the women that he saw on the trail doesn't comport with the three individuals, Rayleigh Voorhees and the others that reported seeing Bridge Guy on the trail. So the obvious answer is that Richard Allen is not Bridge Guy. That's why he doesn't meet any of those definitions, and therefore the timeline is wrong.
State response.
Right. So I won't hammer waiver and harmless error anymore, but there's that. But also, so there are two sides to a Franks memo. There's so-called Franks and there's reverse Franks, and so the Franks is what they put in that's false, and then the reverse Franks is the stuff they omitted. If you just strike out Blair, and I think I've already said this, you strike out Blair and Carbach, and you have a guy who more or less at the same time is out on the trail, says he was out on the bridge, and that's the Doolin report. And my friend on the other side said he corrected that later. I would say that at best he forgot when he was out there, and at worst he was intentionally lying at his subsequent interview to say he was there at 12 to 1:30. And you have a guy on the trail in the same time frame on the bridge. Doesn't matter whether it's the platform or not. Leave Betsy Blair out, and who looks like apparently the last person to have seen the girls alive. That's enough for probable cause.
Okay, reply.
If Andrea, if you have anything.
Well, so first off, again, I think that you have to misstate or overlook critical elements of that initial statement to Officer Doolin to come up with this conclusion that necessarily then he was the killer. We have to overlook, first off, he put himself as parking at the old Farm Bureau building. This is not where the state is alleging that he parked, nor does there appear to be like any real effort to clarify or nail down, if they were confused about where he meant. Nothing about that at the time. He clearly stated he saw 3 females, one of whom was taller, not the 4 of them. And then just otherwise, described his walk out into the area. Otherwise, didn't see anything significant. So you're stuck with having to reconcile one of 2 possibilities. The timeline is wrong, or Richard Allen didn't tell the truth back in 2017 in his very first interview about who he saw. These are both, I suppose, possible, but do they, necessarily lead us to a conclusion that Richard Allen is therefore, likely the killer? I don't think it's enough to get us there. Just the fact that somebody is present on the trail. We heard testimony from lots of witnesses. It was a beautiful day. This was unseasonably warm. Lots of people were out there. Somebody, I think it might have been Cheyenne, testified about having to drive like around to try to find a parking spot because there were so many people out that day. So in and of itself, presence is not and should not be enough to be able to get a search warrant, barring something more specific that can tie him to the crime itself.
Thank you.
They got an extra minute. I want a minute.
I'm always going over, so I'm going to push my boundaries every time I can.
I want the court.
You get a minute. Go.
The standard for probable cause is really low, and it is not mere presence. It is that he's there in the time frame, and he looks at least arguably like the guy in the photograph that had been made public. Okay. It is not mere presence, okay. and we know that the guy whom he possibly resembles is probably the last person to have seen the girls. That's not mere presence.
Okay, thank you. All right, next question is addressed to you, Michael. The Indiana State Police in 2019 released Blair's sketch publicly, called it the face of Bridge Guy, and said Blair and Carbaugh saw not the same person. Then, at trial, the state told the jury that they were the same person. How does the state explain that reversal to the appellate court?
Well, I don't think there was any issue. So there was an issue raised by the defense in the appeal about the admissibility of the sketches, but I don't think the way you explain that is that whatever Ms. Blair's description was, she positively identified the picture of Bridge Guy as the person she saw on the platform, even if the description was off, and the defense would have been free to impeach her identification of the person in the Bridge Guy photo as whom she saw with her description.
Are you done?
I'm finished.
Response?
All right, I'll go. So here's the thing. First of all, the defense was not able to impeach her because the state prevented them from impeaching her. But, at the end of the day, it's probable cause, is the totality of the facts and circumstances known to the officer at the time that would reasonably leave. Well, we're talking about for a search, so not for an arrest, but it's when you muddy the waters and you lie to the magistrate and then try to say all those lies don't matter, and it all establishes the same thing because he puts himself in the general area. I do think it leans towards mere presence because everybody looks like that guy in the video. Everybody anybody could look, any white male could look like that guy in the video. And all of the witnesses, some of the witnesses said the person that they passed was tall. He is a short man. No one described him as short. And there is a pattern that the state has shown absolutely, positively, hands down, that they've got, that they've got no issue with omitting things, misleading things, changing things to try and fit everything into a box that's not there. And the affidavit even presenting Alan's clothing description as a confident identification of a blue Carhartt, when Alan said he didn't remember and listed everything he owns, it presents Alan's timeline as a definitive window when Alan said between maybe 1 and 3. It presents law enforcement's inferences about Alan's parking locations and Alan's own statements when Alan described the non-existent building and pointed to a spot on a photograph. It attributed Carhartt's later interview descriptions in 2017. Each mischaracterization moves in the same direction towards inculpating him and away from the qualifications, the uncertainties, and the inconsistencies that the magistrate was entitled to weigh, period.
Okay. And Andrea, if you have more to add, I'll let you do it in the reply. Response, state.
Well, again,
Wasn't I
so
responding?
if you set aside, so now we're into the omission part, and there's nothing that undermines simply the time frame and the resemblance of Bridge Guy to Rick Allen, or Rick Allen to Bridge Guy in the photograph. And it is not mere presence. It is the time. And sure, there are a lot of people who may look like Bridge Guy, but nobody identified a lot of people out there who looked like Bridge Guy. Rick Allen said he was out there, and he kind of looks like Bridge Guy now. And again, I go back to waiver and harmlessness too, because of the confession.
Yep.
Okay. Sir, reply. I keep forgetting who I asked the question, so I keep screwing up response and reply.
Well, I think the challenge here is that so much of the argument of this evidence, the interpretation of this evidence, it comes down to bootstrapping, because there is an assumption that the person that Betsy Blair and Sarah Carbaugh and Rayleigh Voorhees all saw on the trail is the same person as Bridge Guy, even though their own physical descriptions and the sketch that Betsy produced and so forth look nothing like the photograph of Bridge Guy that was taken from the phone. But then also you have the kind of assumption that it must be Bridge Guy because there was nobody else out on the trail, as though a person could not have, waited, like lurked in hiding in the trail, or somebody could not have approached the trail from a different direction, approached the bridge from the other side, or something like that. Now, these are all factual issues. That's the problem with appeal, is appeal doesn't really care so much about the facts. They care about interpretation of the facts. The problem is just that when we are talking about the warrant and the probable cause needed to get a warrant, yes, granted that it's a low standard, it doesn't require a lot, but it is a totality of the circumstances test, and so you are inherently tipping the scale anytime you decide, I'm not going to mention these circumstances, and I'm going to make up a few other ones to dribble in. You are inherently giving the court a false impression of the strength of the case. And so the right thing to do is to go back and look at that information, resubmit it to the magistrate with the information that is accurate, that is correct, that isn't being colored and bootstrapped, and let the determination be made based on those circumstances.
Okay, very nice. Okay, ladies, even if you're right on the merits, the state says that Allen can't get fruit of the poisonous tree suppressions of the confessions because he never raised a Fourth Amendment challenge to the confessions below. and his one sentence argument on appeal is insufficient. Isn't that a separate waiver problem?
I would say so. So I'll let Andrea argue it. Ah,
Well, it comes down to, I think, just the question of remedy. He has presented the problems with the confessions, certainly in due process terms, but that's getting more to the voluntariness argument, and not as the product of the search warrant that shouldn't have been granted, that led to him being arrested and therefore detained and therefore confessing. So to me, the Fourth Amendment challenge is really not the primary consideration, although maybe it is just on somewhat technical grounds. It's just much more that even if that issue had been preserved, there's a challenge with the attenuation of that, because so many things have to happen in between Liggett putting false statements in a warrant and Richard Allen, giving these quote unquote confessions months down the road. This was not an inevitable consequence of that warrant. So because of that, can they really fairly attribute all of it to the warrant? That's where I think there needs to be some more some more development of this particular issue in the reply, because I mean, if we have a waiver problem, we have a waiver problem with the whole issue. It doesn't, I don't know that it necessarily matters that we've got a, specific Fourth Amendment issue here versus a, you didn't object to the evidence at a later point. Like the end result of that is kind of all going to be the same. But if the court is going to consider this as being preserved adequately in the record, then I think you still have a long way to go to show that on the merits, the relief that's being requested is justified on these grounds.
Allie, anything?
I mean, I honestly can't support that argument that the defense made. So I'll stay in my role here. Character.
All right. Response, State.
It's easy. There's a double waiver. There was no objection on Fourth Amendment grounds below, I don't believe. And in the Indiana appellate courts, there is a thing, you waive an issue by failing to make any cogent argument. And I don't think there's any cogent argument attached to the Fourth Amendment claim to suppress the confessions. And it is a clear case of attenuation if waiver doesn't apply. End of story.
Andrea, reply.
It's a tough argument.
Right.
This one's a challenge. I would not personally probably be pushing too hard for getting the confessions thrown out on this particular basis. I think they're much stronger, trying to focus on the primary search itself, the search of the home, the firearm, the little gun, the bullet in the keepsake box, and those types of things that, but for the warrant, would not have been justified. And I gotta point out too, just because I'm still on this warrant, and yes, PC is the low and all that, but you also have to have a reason to justify going into that particular home. It's not enough just to be like, okay, we have information that leads us to believe Richard Allen might be the perpetrator. You also have to believe there might be evidence in this particular place that you're searching now years down the road. So if you combine the paucity of that type of information with the challenges surrounding the timeline and the totality of the circumstances, it just raises more questions about whether this was a reasonable search warrant under the Fourth Amendment.
Michael, sir, reply.
No.
Okay. Okay, we're going to switch to issue 2, the voluntariness of the confessions. My first question is to Michael. The state's brief describes Allen's conditions at Westville almost like a well-appointed facility: tablet, books, commissary, in-person visits, a replacement window. But this man was eating his own feces. banging his head until he had 2 black eyes on a concrete wall and was carried catatonic to the infirmary. How do you reconcile the brochure version with the video version?
I don't, and I hold no brief at all for how the state described this. What the description was horrible. It was clearly, if I were writing the state's brief, I would say right up front, but based on Bell v. Wolfish, 1979 Supreme Court case, that holding him in those conditions was absolutely a violation of due process. You cannot hold a pretrial detainee in conditions that amount to punishment. And it's almost literally what it says. But I would also say that you cannot show causation from that to his confessions. But the limited question you asked was, how do I reconcile the state's description? I don't. And it is absolutely shameful that those lawyers did that.
Okay, so Michael got out of his lane a bit there, but I'm going to give
No,
you-
I'm the appeals division supervisor who is at oral argument in front of the Court of Appeals, answering your question, saying, sorry, we shouldn't have said that. And
Fair.
but it still does not affect the case.
Fair. Ladies, response.
I was gonna just save it for your next question.
Well, my response is that we do have evidence in the record that the conditions were directly responsible for Mr. Allen's deterioration in his condition and his psychosis. That was what Polly Westcott was allowed to testify to. Part of the problem, once again, is the bootstrapping, the selectiveness of the evidence. We had a professor, Dr. Gracian, who was willing to testify that these are false. These bear all of the hallmarks of false confessions that are produced by the stress of the circumstances. So it's a little bit difficult to fault Mr. Allen for not raising an argument that he did in fact attempt to raise and was precluded from doing so by the trial court. So I think all of those things taken collectively do raise a question about whether these confessions were caused by the deterioration of his condition that was the direct result of his confinement under the conditions that were described.
State reply.
Clearly, he doesn't have one.
He doesn't have to. He can pass.
He just told the court that he disagreed with his own argument. So
okay, we will move to the next question.
But I don't. So holding somebody in something that results. So the conditions under which I can confess that he was held under conditions that were unconstitutional. Period. That doesn't. Yes, the confessions may have resulted, but that was also a question for first the judge, then the jury, and at least, and again, I'm going to have to defer to Andrea because she knows Ms. Burkhart because she knows the record better. But there were at least 2 phone calls where he confessed, where although maybe he was psychotic, he sounded normal. And my friends on the other side are free to disagree, but the Judge Gull was in a position to rule on the admissibility, whether the state had proven by a preponderance of the evidence that they were voluntary. I think the voluntariness issue's been waived. The coercion part of it,
we're getting to that next.
I understand. So anyway, I'll leave it at that then.
Sir, reply, or do you want to?
No, just the next question. I think goes into this.
Okay. Defense. The state's Connolly argument is a fortress. There's no interrogation, no threats, no promises, no denial of counsel. Every federal circuit that's addressed solitary confinement and confessions has said confinement alone is not enough. Where's the coercive state action?
So here you have to look at the confinement conditions here, a complete picture of it. The state tries to emphasize that Alan had food, clothing, a window, medical care, and contact with family, which I'll maybe Andrea can tell me if that's even true. I'm not sure if all those facts are top on your mind right now. But Alan's brief establishes that he was in an 8x4 times 12x5 cell. Met his psychologist while shackled in a 3x3 cage, had no human contact except while caged or chained, was recorded continuously, and was the first pretrial safekeeper in any IDOC employee's memory placed in that specific restrictive housing unit. But both accounts are supported by citations to the record, and they're telling a very different picture. But the complete picture is conditions less barbaric than nakedness, windowless isolation, and bread and water deprivation. And I think that was the Brooks case, but significantly more restrictive, obviously, than your ordinary pretrial detention, imposed knowingly on a defendant with diagnosed major depressive disorder and prior suicidal ideation, is acknowledged violation of IDOC's own 30-day SMI policy. So I think that takes this case that where you can't just say, well, this is not as barbaric as what was it? I think it was Brooks in Brooks, but you have to add to that this whole, his whole mental state and SMI and clear evidence that he was, was losing it. And when you take that, Alan's brief establishes that Alan filed his emergency on April 5th, filed an emergency transfer motion. The prosecutor waited 9 days to respond while investigating the monitored real-time confessions. But on the same day, the prosecutor characterized defense counsel's concerns as colorful and dramatic. IDOC's over there finding Alan's gravely disabled. I mean, law enforcement spent hundreds of hours monitoring, collecting Alan's statements, interviewed everybody, sent a psychologist to speak with Dr. Walla. The state's characterization of the confessions as purely volunteered statements untainted by state involvement is difficult to reconcile with the extent of the state's active collection and monitoring efforts. And when you take all of that and you consider Dr. Walla's admissions, I mean, she admitted on cross-examination that with hindsight, she was on the fence about whether he had been genuinely psychotic. At times, she previously characterized him as not psychotic. The state brief does not acknowledge this significant concession that Dr. Walla, made on the stand. She destroyed her handwritten notes, leaving only her documentation. And the state's brief does not even mention that. So the formal, the lack of documentation simultaneously acknowledged psychotic symptoms while characterizing them as feigning for secondary gain. Again, a characterization Dr. Walla retreated from on the stand. So I think that because of that this can get more into the kind of barbaric situation that they considered in Brooks, the nakedness, windowless isolation, bread and water, like the worst barbaric situation that you can imagine. And again, I do acknowledge that this is not that, but it's damn well close to it. And when you add his mental state, violation of their own policy, that they saw all of these things, that they were watching, and they let it develop, I think that takes this into a different closer to a barbaric situation.
Okay, Andrea, I'm going to give you time here because while I found everything compelling as a moderator, what Allison said, I don't know if she addressed the question, which is where is the coercive state action?
Yeah, I think there's a couple points here. First, the defense clearly throughout their brief is arguing psychological coercion. They aren't arguing that this is a situation where somebody, came in and held a gun to his head, even though I think they have ample facts to make that kind of argument, given the actual physical deterioration that Mr. Allen suffered, the beatings that he endured, and the other types of physical punishments that he was subject to. But I think you also have examples in the appellant's brief about the state's exploitation of that condition and his deterioration. And the best example of that was the prosecutor delaying their response to his safekeeping motion, and during that time monitoring the phone calls that he's making while he is making these, quote unquote confessions. And so this is showing a deliberate inaction on the part of the state to not address a serious physical and mental health decline in favor of exploiting the opportunity to obtain evidence to use against him. And so I would argue that is sufficient to show the state coercion.
And Michael, response to that, do you consider that to be coercive state action?
No, but may I step out of my white hat?
No, you have to stay in the white hat.
Come on.
All right.
Go ahead, Michael.
So the best argument for state coercion that is something we learned from Stacy and Mark's brief that I don't think was otherwise publicly known was Dr. Walla not giving Rick's stuff back until there would be more consistency.
Mm-hmm.
Okay, back to white hat.
So and I'll follow up on that in my
wait for it. Wait for it. You can get a reply.
Yeah, I don't know what the evidence of monitoring and waiting for confessions was. I do want to say something about there are actually two arguments in Stacy and Mark's brief, and the state answers both of them. But I think even though under Colorado v. Conley, the state has to prove voluntariness by a preponderance of the evidence, under the Indiana Constitution, they have to prove voluntariness beyond a reasonable doubt.
Mm-hmm.
And I actually know the whole story of how that split happens, but I won't get into that here. It goes all the way back to Miranda. And the Indiana constitutional claim is waived because I don't think the lawyers made it. And the preponderance of the evidence standard is going to be reviewed for clear error, letting them in. The evidence is ambiguous on causation and what the state was doing. And this court can't substitute its judgment on that issue for Judge Gull's.
And just touching on the Walla situation, and it does not matter what her intention was. If she was trying to say, I need more consistency because I need to know that your mental health is more consistent, or whatever her subjective intent was, it was a reasonable determination of the listener, Richard Allen, in his mental state, to assume he had to give her more of what she wanted to get any of what he wanted. And I think we will find this contact with family, I can't be 100%, we'll have to wait for the reply, was after he made these confessions. So after he gave her what he thought she wanted, even if the state can argue that's not what she was trying to convey, it was reasonably conveyed that to make her happy equals me getting some very basic rights. State action. That's it.
Okay. All right. This is to the state. Michael, let me challenge you on causation. The state says that Allen confessed because of religion and discovery, not confinement. But he'd been sitting in that cell for 5 months before any of that happened. If the conditions were fine, then why was he already a broken man within 2 weeks and telling his wife that he'd tell them whatever they wanted to know in November of 2022?
Yeah, I don't know. I don't know that when he was broken is relevant. Again, the causation, they put him in, there's a result, but there has to, again, I think the coercion part of it was raised, but I really don't think the voluntariness question was preserved. All coerced confessions are involuntary, but not all involuntary confessions are coerced. And I think the state correctly argues that the conditions of confinement, I mean, absent beatings, don't amount to coercion because you're not directing anybody. Now, if you want to, they really haven't made a case that he was being directed to a confession.
Is that it?
That's it.
Response?
If you've got anything, Andrea.
I mean, I think the challenge that we have here, that the defense has pointed out, we got two problems here. On the one hand, we've got a post hoc ergo propter hoc analysis, right? We've got that type of issue here. He confessed after all of this time in solitary confinement, but that in and of itself isn't proof that he confessed because of the involuntary, the solitary confinement. So that's one side of our problem with the reasoning. But the other side of it is that he is only going to, confess because of his mental illness after the fact. And so we're back into this problem where we had an expert that was proposed to be able to address some of these nuances, some of these problems, and to kind of show us how this road goes from the solitary confinement and the psychological coercion that inflicts on somebody to this process of confabulation, or just flat out making something up for purposes of pleasing the person who's got the control in that confinement situation. So the fact that he felt that he had this need to appease Dr. Walla, if not anybody else, that tends to be a pretty good indicator of his own perspective on what he understood the circumstances to be. And so then the state's willingness to exploit that, to take advantage of that after the fact, is the type of fact that should be construed against the state, since it's ultimately their burden to prove, not just under the federal standard by a preponderance of the evidence, but under the Indiana Constitution beyond a reasonable doubt. And it can't meet that standard on ambiguous evidence.
Okay. Mr. Ausbrook, I'd like to ask you, in terms of your reply, if, assuming arguendo, if after 5 months of these conditions and they see Richard Allen breaking down, if, again, arguendo, if one of the guards simply said, "Oh, you want to see your wife, Kathy? You want to get out of this hellhole? Just tell us you did it." Would you consider that to be coercive state action?
Sure. Under Colorado v. Connolly, that's assuming the guard had any sort of authority, and I suppose Mr. Allen would think that he did, that's a promise. That's getting something for he's offering something for the confession. It's like paying a witness.
And I would argue that that's what happens when Wallace says, I need to see some more consistency from you when he asks for things. That's a promise. And he was free to interpret that I need more consistency from you as seeing when I say things they want, they take that as a good thing. So this means I need to say more things that she wants.
But so on the state side, I would argue there is no record of what that was she was asking for by way of consistency. Plus, I don't know what the timing is. And her saying you don't get your stuff back without more consistency. There's nothing in the record about that, and how it relates to at least the 2 phone calls where one might think that Rick Allen is talking relatively normally. And to go to the experts, the law in Indiana is pretty clear. The experts should have, I don't know whether this evidence would try to get in. Experts are allowed to say this confession bears all the hallmarks of a false confession, but we aren't really talking. So there was no false confession part of this. It was, we want to suppress the confessions. And I don't think that the defense went to the experts are not allowed in Indiana to testify this was a false confession.
Okay.
Well, and I can I just say one more thing?
Briefly.
Okay. So you have to think about this, the established the timing of the Haldol. You've got, he was administered Haldol April 14th and April 17th. He received long-acting Haldol on April 18th. On May 2nd, Allen was very tangential. This is according to I think, what's her name again?
Walla,
yes. Tangential, repeating himself, jumping between topics, saying things like, I killed Abby and Libby. I will kill everyone else. I will wipe out the whole world after I die, mentioning World War III, confusing nightmares and reality, thinking he had schizophrenia, randomly saying methamphetamine, and telling people he loved them. The day before May 3rd, Dr. Walla was unable to have a meaningful conversation with him. On May 3rd, Allen feared missing Easter, thought his interactions with Dr. Walla were fake, and was paranoid about his safety, alongside with confessions Walla documented. On May 25th, and then it goes on from there. But I'm just saying, you cannot say that they argue he returned to a baseline and he sounded normal on May 3rd. You can sound normal and still have psychotic thinking, still have delusional thinking, still be confused. And that is why we needed the expert.
what expert was excluded? I mean, I just don't know enough.
What's his name?
Gracian wasn't totally excluded, but he was limited in what he was able to testify to. He wasn't able to analyze. He wasn't able to apply the general information that he testified about to the details of Mr. Allen's statements. And that's beyond just the ultimate opinion of, I think these are false confessions, but even just being able to walk through the analysis of, here's one characteristic of false confessions, and here are things that I see in Richard Allen's interviews.
Okay. So you guys essentially were digging into the next question. I'm talking to you, the defense, who this question is posed to. The temporal disconnect is a real problem for the defense. Allen confessed before psychosis, according to the state, and after psychosis. His most detailed confession was on May 3rd, when Dr. Martin said that he was at baseline. How do you explain that?
Since I just touched on, I'll let Andrea go.
Well, Dr. Martin's testimony that he's at baseline is contradicted by Dr. Martin's decision to continue involuntarily administering Haldol to him for another at least 45 days after that. He got his final involuntary injection, I believe, on June 16th. So at least for treatment purposes, he was still being treated as though he was floridly psychotic at that time. So whatever kind of subjective interpretation of, he sounded normal or he looked like he was back at baseline is directly contradicted by their own treatment decisions.
And by the records I just mentioned of Walla. So,
State.
I don't have anything about that.
You got nothing to say about that? Okay.
No, I mean, if we're talking about the exclusion, under the headings we got, we're not. I don't think the exclusion of Gracian's testimony was raised as an error. Perhaps it was, but I don't recall that. And
I hope so.
On the record, I don't disagree that everything learned counsel on the other side said may well be true, but that's not what the record in this case really says. That was in front of the jury, and the jury, perhaps mistakenly, but that's not their fault, could reasonably conclude that Rick Allen and at least some of the confessions sounded completely rational.
And just the defense did raise the issue. It's under E. The court committed reversible error by excluding evidence that impeached the credibility of Allen's confessions. The trial. So it is sort of in a different heading that you said we were in voluntariness or something, but they argued the trial court erred by excluding statements and behaviors that provided the foundation for Dr. Gracian's opinion that Allen's confessions were not credible. And I think that needed to be reframed to his opinion that Allen was displaying symptoms of false memories, and to keep it off the ultimate opinion issue. But maybe you touch on that later.
Okay. This is to Michael. Michael, the detail that only the killer would know, the van, that's your strongest corroboration. But the defense has surveillance video suggesting that Weber didn't get home until 2:44, which is 12 minutes after the phone stopped moving. Doesn't that actually prove that the van detail is wrong?
Well, the van detail only came up in the motion to correct error. We dispute it. There was never a hearing to establish how far off the time was on the van video. As the evidence stood at trial, it was absolutely a detail only the killer would know.
Okay. Response?
Get in.
Yes, according to our record, I believe the white van is in discovery, and we do know that in the timeline of Richard Allen's decompensation beginning towards the end of March and going into April, this does correspond with his discovery being made available to him. So to the extent it is in the discovery, then it is something that anybody with access to that discovery would know, including Mr. Allen at that point.
And then I'm assuming you're going to ask us about the motion to correct error, so I could save my comments for that section. I don't know.
I wouldn't assume anything.
All right. Well, and do you guys call it, because I know, and Miss Burkhart, you call it Napu, right?
Napui.
Napui. And what do you call it, Mr. Ausbrook?
Napui.
Okay, so I have to say Napui. I figured you two are saying it right. I said before, well, if Andrea says Napui, I don't know. So, but before like examining the Napui question of it, you've got to address like a methodological. Why can't I speak? But whatever. The phone data established objective facts, right? LG recorded a video at 2:13. LG's phone stopped registering movement at 2:32. This is the state, okay? Now the state has to be held to its own theory. They can't, when it works for them, say this is the time the murder occurred. This is the last movement of these little girls. What those facts mean for the time of death is the state's inference, okay? The state theorized that the murders were completed by approximately 3:22 based on the cessation of the phone movement. So obviously the defense has contested that time, but the murders were completed by approximately 2:32 based on the state's evidence. Allen's May 3rd confession to Dr. Walla includes this detail that the state characterizes as only the killer would know he saw the van. You know, but the state elicited testimony from Brad that he drove directly home after clocking out at 2:02. And the prosecutor argued in closing that the timeline matches perfectly. But you've got the two pieces of evidence suggesting that Weber's arrival home was later than his testimony implied. And the state damn well knew about it. Security camera footage from Weber's neighborhood showing Weber arriving home at approximately 2:44 p.m. An FBI report reflecting Weber's cell phone arriving home at the home location at approximately 2:50. The state knew these two things. I think it is disingenuous and unfair and a violation of his Sixth Amendment rights, end of NAPU, for the state to turn around and argue to this court, hey, there's no evidence that our evidence is accurate because the defense didn't do their job. That's not the question. You had evidence that called this into question, yet you went on and told this jury that this is when it happened, and Weber, arriving home at what, 15 minutes, 12 minutes later, 12 to whatever minutes later, post-dated the critical events by 12 to 18 minutes. So Allen's confession that he saw a van and changed plans, therefore, cannot be corroborated by Weber's arrival because the state's own timeline of events Allen described as his reason for changing plans were complete before the van arrived. And the state argues the direction and magnitude of the camera timestamp error are unverified. These are things that should have been addressed in response to the motion to correct errors. And the court failed to hold that hearing. So I think that worst case, they should send it back for a hearing, develop the record. What did the state know? And talk about the Glossip violation, NAPUI Glossip. Glossip, it extends NAPUI. It takes things into, a different framework that violations demonstrate, when there's false testimony, the prosecutor knew or should have known was false and a reasonable likelihood that it affected the verdict. There you go. Weber didn't testify to an exact arrival time, which the state correctly notes complicates the demonstrably false prong. However, the state possesses the surveillance video and the FBI ping report, and they argued in closing the timeline matched perfectly. If the state's own disclosed evidence suggests Weber arrived 12 to 18 minutes after the murder window on the state's own theory, then their perfect match closing misrepresented the evidence, the evidentiary record, regardless of whether Weber's individual testimony was technically false. And that falls in line with Glossip.
You're well over time, by the way. State.
So, on the facts, I will absolutely go with the state's response that at least part of it, and that is the time Weber got home is disputed. The time on the security cam is disputed. And what I would not do, and if I were in the Court of Appeals, I would withdraw the part where they try to argue that it's harmless. I mean, NAPUI error is, I've never seen a harmless NAPUI case. As put in Glossip, the state has to prove beyond a reasonable doubt that the false evidence had there's no reasonable chance it affected the verdict. It was a centerpiece of the state's closing argument. But I would be arguing as the state would be, this is disputed, they haven't shown it's false, but they did ask for a hearing. If Judge Gull didn't have a hearing, she denied it. If the court thinks that there needs to be hearing on this, then the court should remand it. We don't think that's necessary. It should affirm on this issue, but at worst, send it down for a hearing.
Yeah, and I know that was a tough one for you, considering that you wrote the motion to correct error. So I acknowledge that. Okay, question 14.
I wanted a hearing.
I know you did. Ladies, the state argues that the van detail is something that only the killer would know, but Allen also confessed to shooting the girls and molesting family members, things that didn't happen. How is the reply brief going to deal with the confessions that contain accurate details alongside of the confessions that are demonstrably false?
Well, I think it relates to the assignment of error that Ali just pointed out about the exclusion of the context that was needed to be able to evaluate what Dr. Gracian was saying about false confessions, because the jury didn't get to hear any of these things. Whenever Richard Allen wanted to present his own statements, it's self-serving hearsay. He doesn't get to admit that. So it allowed the state to, again, just cherry pick which statements the jury got to hear, and then the jury is left with the impression that these are all of the statements that he made. And so the problem is that, once again, when you look at the totality of the circumstances, you look at everything that he said, and you look at the context in which he said it and how that corresponds with the things that the state really wants us to believe versus the things that, plainly can't be believable, and the state, didn't want them to come in the first place. Those are all going to support the argument for why this was necessary to be able to evaluate Dr. Gracian's testimony and why he was there in court in the first place, because he was there to show this is very predictably how the process of developing a false memory works. And it has certain hallmarks. And here are many, things that you can look to that will show if a confession is consistent with these hallmarks or not. The false facts that he confessed to are a prime example of that. The fact that he, alleged to have committed all kinds of things that were, demonstrably untrue, that his own family members got on the stand to deny that anything like that had ever happened, and so forth. These go to corroborating the basis for believing that this confession was false. And so the argument from the defense is that if if he's not believable during this time frame, you can't really just pick and choose which parts we think we want to hear, which parts we want to say, okay, yes, these are valid, versus these other ones, we think are no good. So, provided that there is, like I said, in the record, evidence of the white van that would have been provided to him in discovery, it would have been something that he could have known beforehand. It would have been something that anybody who reviewed the discovery could have known and could have brought to his attention. Then it doesn't corroborate the main point that the state wants to make with it, which is simply that there's only one way that he could have acquired the information, and that was to be present at the time. So I think rebutting that is just going to go hand in hand with this argument for why more of Dr. Gracian's evidence, the foundation, the bases for his opinion needed to be allowed into evidence for that to really be fully assessed by the jury.
And as the defense has pointed out, and my co-counsel has made abundantly clear numerous times, the statements that the defense is trying to admit are not for the truth of the matter asserted. This is not a situation where the defendant has denied culpability and they're trying to get in their self-serving hearsay. when it's not being offered for the truth of the matter, it has and moreover, it has a non-hearsay purpose, which it goes to his state of mind and the credibility and reliability and voluntariness of his statements. So I think that the error of refusing to give the jury all of that background and to put in is this only about facts? I forget what your question was.
Wow.
Because I wanted to go on to the whole bookends of the calls, but I'll wait because I don't think that we're there. But I would expect the reply to touch on this opinion of the state that a defendant is not allowed to put in his own statements when it goes to state of mind, that's somehow only allowed when the prosecution wishes to do it. And
Okay.
I would ask my opposing counsel here, what support is there for the proposition that the defense cannot put in the defendant's own statements for state of mind?
State.
That's a low blow, Ms. Motta, after the conversation we had this afternoon.
Yep.
That's a low blow.
Sometimes the state needs to concede a misapprehension of their.
The only time, let me put it this way. The only time that the defendant cannot put in his own statements for state of mind is when the judge makes the objection on hearsay grounds for the state.
And for all of you out there, that's what happened here. The state did not object on hearsay grounds. The judge sua sponte objected for the state on hearsay grounds when these are not statements offered for the truth of the matter asserted, which is rule 1 of what constitutes hearsay.
Okay. All right. So
before you
Andrea-
get too far into the next question, I'm afraid there's of course still a billion things to go over because this is the Richard Allen case, and so it can't be simple. It's got to be insanely complicated. But unfortunately, I have to dip.
I knew this going in. So can I get you to promise that you'll come back and we'll do a part 2 and finish it out?
Sure.
And do you have any closing statements?
Do you have any closing statements as
or
to
thoughts?
the first 2 issues or thoughts? Yes.
Again, it just for me continues to come back to big picture, and it kind of always has. This is a situation where if the courts want to decide it on legal niceties, they certainly can. They have every right to do that. But if they do care about getting a right outcome, and I am optimistic enough, not quite black-pilled enough to think that judges have completely jettisoned this idea of, maybe our court should do actual justice and stuff. If there is any case that has, significant concerns from just a basic factual standpoint and kind of transparently circular argumentation from the state about why they're right and why they have the right guy. See, both of these ladies identified Bridge Guy, and so the fact they never identified Richard Allen as Bridge Guy is actually totally fine. It's not a problem at all. In fact, he looks nothing like Bridge Guy, but it doesn't matter. These things are so gaslighty and so obvious that it's just hard for me to read the appellant's brief. And I was very impressed with the way that they presented it, really from the standpoint of here's the problem with the information that the jury got and kind of what the reality on the ground is. And so ultimately, if the court does care about that, then my view is they can find a way through the legal issues. Maybe not a guarantee, but it certainly at least gives them the motivation to look for it. If they don't have that at all, then it's very easy to,
Waiver
looks good. Non-preservation looks good. These issues, let us make an easy decision and not have to get too down into the weeds with these much deeper problems. So it's never good. to have these kinds of procedural objections in your way, and it's one of the challenges in appellate work. I know we've all of us on the screen have talked about multiple times just the problems with appeal and the difference between appeal and the different post-conviction remedies and where ineffective assistance fits in, and like all these things that nobody really wants to have to go down that road. But it's just the nature of the appeal process being limited that we might be stuck with it. So I remain optimistic that justice matters, but we'll see. We'll see.
Thanks, Andrea. We
Thanks,
appreciate
Andrea.
you.
You're the best. We love you.
All right. Thanks, guys. We'll see you soon.
See you
Bye.
soon.
Why don't we take some questions? I know that people will love to get some questions answered by Mr. Ausbrook here. But first,
You can take your hat off now, Michael, and
yes,
you know,
put on whatever hat you want.
but you're gonna have to put it back on for part 2, which deals with the very juicy evidentiary issues, and then obviously Appellee, you know. So we've still got those out there, and I think, frankly, they're probably the stronger arguments. But you know,
Well, let me say something, and not in the way hat anymore. The easy day for the Court of Appeals, after it's briefed, after Mark and Stacy filed their reply brief, I don't think it goes back for a Frank's hearing. I think that's gone. I mean, I'm sorry. I just have to disagree with Andrea that there's a way around that. And if I'm proven wrong, great.
Seems like waiver to me.
But you send it back down for a gossip hearing.
Yeah. You know, I wonder, you know, because I kind of want to latch on to this hope of like a due process argument that because the judge failed to address this issue at pretrial, it left the defense unable to really reassert objection. I don't know. I just feel like maybe somehow, some way, the failure to provide due process at pretrial can overcome the failure to object.
And by the way, if it does go back for a gossip hearing, right?
Mm.
The state also had evidence that Brad Weber did not leave that parking lot at Subaru until 2:12.
Wow.
and I know you've taken that drive, but before we get to
No, it's not about the drive. It's in Weber's phone.
yeah, but I mean, in terms of the time that it actually takes to get from West Lafayette and that plant and walking to his
Yeah,
car.
and if he didn't leave till 2:12, there's no way he's there about 2:30.
There's no way.
So people are asking about it.
And I want to be clear. I want to be clear. I think Weber thought he got home about 2:30.
Yeah.
So people are asking about a Glossop hearing. So that is the case of Glossop v. Oklahoma. It's a 2025 U.S. Supreme Court case. And Michael, you'll have to tell me if I'm getting some of this wrong, but this was about he was charged with murdering a guy at a hotel, and there was something about like the bookkeeping. I don't know.
Yeah, there was some false evidence that the state knew or should have known was false, and actually there's a dissent in Glossop. I mean, it's a tough case, but the principles that come out of it aren't tough, and what it needs to go back for a hearing on. Okay, well, the state in its brief contests that the timestamps on the security cam video are correct. They say there was no foundation for the time on the FBI subject information sheet, which showed Brad Weber's phone starting to ping at 2:50. Maybe his phone was off. It wasn't, but that's fine.
Right.
And so give the state what it wants. I mean, McClellan, if I had been McClellan and I thought that time was off and I could prove it, I'd have been asking for the damn hearing.
Right. And going back to Glossop, so one of the witnesses or a snitch, whatever he was. He testified that he never had a psychiatric issue and had only like erroneously, accidentally for a cold been prescribed lithium, but the prosecution had in its own files that there was like a complete medical evaluation where they reported the lithium prescription, and his own notes documenting the prescription established that testimony was false. There, the argument was because typically false testimony is testimony the person speaking knows is false. And that's why you're saying, well, you know, their argument, the state's argument that Weber might not have been lying, he might have just been mistaken. That's where they say, no. When the prosecutor, what happened in Glossop, they said the prosecutor knew the testimony was false because they possessed the records establishing that the truth before and during trial. So they could not have knowingly.
It's not about lying. So I want to make it clear. NAPU and Glossop, and Glossop makes it crystal clear.
Right.
And there are 7th Circuit cases saying this already before Glossop. It's not about a witness lying. It's about
the state allowing.
The extreme example I've used before is, imagine there's a robbery case, right? Gas station gets knocked off. There's a security cam video. Shows who did it. You've got a witness. So you got the cashier personally IDs the defendant. Truly thinks it's the defendant. And the video shows doesn't look anything like the defendant. It doesn't matter what the defense does with that. The prosecutor can't sit on that video.
He can't let his witness get on the stand and say, it was him, I'm certain, when you're holding the video that shows it's not him. Even if the defense screws up and like didn't use a video that they were produced. So that would be going back for a Glossop hearing would be, did the state have evidence that they knew that that not only was Weber's testimony false, that he was home by 2:32 or arriving right around then, that's like whatever the timing was, but that then all of the state's arguments about the timeline and about how perfect it is and about how it all lines up is all misleading, knowingly misleading the jury when you have facts and evidence in your possession that contradict the testimony and the state's position. And that would be what it went back for.
And the state's argument, by the way, is that Weber had to have gotten there about 2:25 because that's when, so the phone doesn't move between 2:18 and 2:25. And then the state's argument is the van comes by at about 2:25 and it starts moving again because Rick Allen has been surprised, shocked, whatever. And that's when he hustles the girls across the creek. So you got to be there a lot earlier than 2:32.
But meanwhile, what's her name? Cheyenne Mill is going to the bathroom right over there. She's on the other side, squatting with her friend, the two of them. She specifically said, I looked all around because I didn't want anyone to see me going to the bathroom.
No, there's a lot wrong with this case. But just talking about the sort of the appellate geometry, at least for me, the easy thing for the Court of Appeals is and not get into it, send it back for the Glossop hearing, see what that result is, because the prejudice standard is so bad for the state. If it can be proven that the state, from the evidence in the discovery, knew Brad Weber didn't get home about 2:25, it's over. They don't have to address any of the rest of it.
Right.
And if it can't be done and there is no hearing, that avenue should still be open on post-conviction under an ineffective assistance of counsel argument. If they have an expert review the footage, confirm the timestamp, do all the things that the defense didn't do, right? It could be it could be raised in
I will say one thing, and it upset me a little bit. So we had Matt Hoffman was the one who said this is 12 hours off. I won't say who edited it, and that's all we had. We had the affidavit. It's 12. I mean, that's evidence, right? I mean, he's the investigator. I mean, he wasn't challenged. I mean, it's like a witness getting up there saying, you know, I looked at this, and you know, I know from these people this is 12 hours off. It's no different from what they did with the Hoosier Harvest Store video.
Exactly.
The officer checked his watch,
Right.
whatever. So somebody, and I won't say who, stuck into the damn motion to correct error. We know because of the positions of the sun and the shadows. And it's like, no, we're not guessing from the shadows of the sun, and we don't need the daylight. We have
as confirmed by the shadows of the sun.
Well, but it just makes it all
Right.
sounds like
willy-nilly, right? When you've got an affidavit of someone who says, I looked into this.
You got a souffle. Why do you stick a fork in it so it falls?
Right.
So
Carolyn,
just so people have an understanding of this process, where we're at now, we've had both the appellant and the appellee's brief filed. The defense gets to file a reply brief to the state's brief. So that's the next step here. We're assuming that they're going to be doing that. And after that's done, no more briefs are filed. Everything is going to be reviewed by the appellate court, and then they'll make a ruling and issue an opinion on it. I don't know, Michael, what do you think the time frame reasonably on that is?
Well, I expect they're going to ask for an extension to do the reply. I don't know. I timed it out. I think there's going to be oral argument probably the end of the summer. It could be earlier. It could be July. I don't think so, but maybe. No, an opinion maybe by the end of the year.
Right. And so also explain, Michael, in terms of ineffective assistance of counsel, I mean, the direct appeal typically isn't the place that you're going to handle that, right?
Not in Indiana, not ever, not no way, not no how, unless you're saying your lawyer didn't raise a statute of limitations defense.
So that'll be post-conviction work if
and the wait at the state PD's office at the moment, I just confirmed, is 2 years.
Wow.
That's before they start looking at it. That doesn't mean they can't expedite things, but
wow, that would be very unfortunate. Very unfortunate. And I know you guys have both been very vocal about wanting to get that process started, even just to hunt down witnesses before their memories get too far gone.
Or they die.
Yeah.
All kinds of reasons.
Carolyn, member for 21 months, says, so pumped for this. Thanks, Carolyn, for your continued support. Jason says, let's do this. Having read it so many instances, having it both ways. Yeah. I think I'm butchering that. Melanie Parker says, hi, Andrea, free Rick Allen. I'm looking for questions, but I appreciate just the supers. Go ahead, read, babe.
TJ Talks, $20. Let's do this. Thank you very much. We appreciate that. Dr. Vonda K gifted 5 DD podcast memberships. Thank you, Dr. Vonda. We appreciate that. Classic Overthinker, $2 out of Australia, I believe. Free Rick Allen. Thank you very much. We appreciate that. She Boogies, Lick 'em Low Liggett. Well, we've had a merge of the
Afro Man.
Thanks, Spoogs, for being a consistent supporter of the show. Dr. Vonda, you too. Member for 19 months. I invited the AG on Twitter to join us. I saw that. Did you guys see him in chat? I didn't see.
Why, the AG's openly talking about this?
No.
Oh.
Somebody tweeted at him that we were doing this and that he should come take a peek. Sleuther75, thank you for becoming a new member. And for you get a family hug. Aw, family hug. Welcome, welcome, welcome. We always appreciate that. Amanda, such a great idea with so many great attorneys. Thank you.
Can I say something more about what
Of course.
Andrea's closing words?
Of course.
And that is, I really think the Court of Appeals is going to be unwilling to look past waivers, etc. To her point about hoping that it's at some level about justice and not just the technicalities, I think it's the Indiana Supreme Court that is more likely to pull something surprising to get past waiver or some other procedural problem. I don't think and I'm not saying they're likely to do it, but they're the ones who will do it, if anyone.
So would that be the same lawyers that would file the leave to appeal to the Supreme Court?
Yeah, it's called a petition to transfer in Indiana.
Okay.
And it's a little unusual because what happens when they grant transfer is it's not reviewing the Court of Appeals decision. They grant transfer, it's as if the appeal had been originally filed in the Supreme Court.
Wow. So it's all de novo.
Yeah, they vacate the Court of Appeals opinion and then redo it themselves.
So do you find that they still tend to touch on or give deference to the Court of Appeals opinion, or they don't even look at it and they look at it as a blank slate?
You know, if they don't want to do something they're on their own, they're not going to grant transfers to start with. And I mean, there are things that the Indiana Supreme Court has done. I mean, they're a law unto themselves, and I mean, they do surprising things that are terrible on the defense side, and they do really surprising things that are really terrible for the prosecution. I mean, they really are. The Indiana Supreme Court really is the box of chocolates. You never know what you're going to get.
I mean, that's where you wish you would have liked to see a bias issue raised in the brief would have really spoke to those justices on the Supreme Court that already kind of took issue with the way she was handling things.
You know, I've said before that I certainly think I would have been making, now the general rule is you can't make out a case for judicial bias from the court's orders. But I think if there was ever a case to do that, this was it.
Yeah. Yeah.
All right, let's keep plowing through here. Cupcake Diaries 87, member for 1 month. Oh, thank you. This was so fun. Thank you for doing this. Well, thank you for being here. Amanda gave a super and then became a new member. Oh, family hug. Welcome, welcome, welcome. Jason McClellan says the defense's appeal should have argued incompetent counsel for Andy, Brad, and Jennifer. The one time I was doing appeals, my boss said, always blame trial counsel. That's why the appeal is best done by another lawyer.
And that's what, but what Michael was just pointing out is in Indiana, their case law establishes, no, you save that for a post-conviction period.
Because you only get to raise it once, and you never. And it's the same in the Seventh Circuit. It's the same most places.
Yeah, I mean, in Illinois, they say they're typically better heard on in a post-conviction, but if it's evident on the record, such as these objections, you had to raise it in your direct appeal. So that is different than.
But you can still raise it later for things that aren't in the record.
Correct.
Right?
If it's outside of the record,
you can't do that in Indiana.
Right.
And thank you for that, Jason. We appreciate it. Afton, thank you very much. Gifted 5DD podcast memberships. Got some new family members. Thank you, thank you, thank you. Shan Pickle, new member. Oh, family hug for you. Thank you very much. Made of Questions, member for 1 month. Are facts assumed true?
I love.
In appeal.
No, I'm gonna dip out for about 3 minutes. Is that okay?
Yeah, we're
Sure.
wrapping up.
Yep.
Oh, you are? Okay, then I'll stick around.
When you finish, do you want to give Josh a call?
So our facts assume true in an appeal for state.
So the only time, it's interesting in Indiana, so the only time you assume the facts in quotation marks are true is if you're raising a sufficiency of the evidence argument. Indiana has a really interesting factual standard for suppression motions, and that is what is it? It's all the facts that support the ruling of the trial court, but you also get to consider facts that are contradicted.
That is interesting.
And the other thing, I mean, you know, there's some technical stuff in the briefs. I mean, there's an interesting thing that so on the audio. So well, we're going to talk about the audio
on the next one, yes. And
Yeah.
by the way, I was answering a call from our daughter, and she was asking me to do something. So that's why you guys, and I thought I muted myself, heard me say we're wrapping up. I wasn't trying to keep you from doing whatever you wanted to do for the
No,
next
I mean, if you
meeting.
want, I mean, I'm certainly available to hang around longer. I need about 3 minutes.
All right.
All right. Yeah. I don't know how much longer. I got to eat dinner, but
That's why I was saying we were.
Okay,
I was
well,
yeah, let's roll through here.
are there any questions?
Yeah, why don't the confessions explain what happened?
Because they don't.
Yeah, I mean, those just wouldn't be considered actual confessions. I did it. It's not a confession. Not, you know, I mean, I think if you're looking at it as a baseline of somebody admitting that they did something, maybe you could make that argument. But in terms of what we in the law consider to be an actual confession, it's not sufficient. It's just not sufficient.
You know, I don't know what the law on this is, but one of the things that, you know, I'd have been raising in the trial court would be, so you got two things happening with Rick in prison. One, he's in custody and he's talking to Walla, and there's this statute in Indiana that says, oh yeah, doctor, you know, communications with doctors are privileged, except in a friggin' murder case. But
crazy.
There are no Miranda warnings in prison.
Right.
For every time. They're not telling him, by the way, everything you tell Dr. Walla is going back to, now that's different for the phone calls that, I mean, they know that those are recorded.
Right.
But, and I have been arguing that up and down the block. And
yeah, I'm with you. I mean, I think like by any measure, Walla was a state actor.
Well, yeah, I mean, but you can't have it both ways, right? We're going to make this special rule for murder cases, so there's no more doctor-patient privilege,
and no warning about it,
and then no warning.
Right.
Exactly.
Ridiculous. That could have been an argument for a change in the law, don't you think?
Yeah, I don't even know what the law is on the subject. So, I mean, so there is law. The place that there's law on this is in capital cases, psychiatric examinations of defendants.
Crazy. Nick points out that Bob does really well imposing the time limits here.
I did for the most
part. He tried.
mean, look. I mean, I had 3 very verbose people that were talking, so
I didn't go over. What are you talking about?
No, you were excellent. Allison was the biggest
actually
violator of the time. I mean, she was just, you know, I mean, I think on a scale of 1 to 10, I fell in at about a 7. Yeah, I was very strict early on, and I started to give a little leeway as we went. You know, if I felt there was an impassioned plea going on, I didn't feel good about cutting it off.
Cassie at the bat, thank you for your 10 Defense Diaries memberships. We appreciate that. Now, Jason says, that's the other thing I don't remember being in Rick Allen's appeal, the fact that details only the killer would know, or an accused with access to disclosure from the state. And I don't know if that was in there or not, but maybe it'll be in the
Reply.
reply. Yeah.
It's possible.
I mean, the word discovery is only in there one time, and it was
I
Oh,
can
wait.
hear Michael's dinner's ready. All right, critical thinker. This was incredible. Thank you all so much. Thank you for your generosity.
That's a false perception.
I
Bob's
silverware.
starving and saying it's somebody else's dinner who's ready.
Right.
I thought I heard your wife back there, preparing a delicious meal. I heard the silverware clanking. So yes, I did jump to a conclusion, I must admit. Thank you so much, critical thinker. We appreciate it. Classic overthinker. Has Kathy been able to visit yet? Is Rick okay? I'm not sure if she's been to Oklahoma. I would hope so. And I honestly don't know the answer as to Rick's state currently. I mean, we can only hope.
Well, and then so Gray SPA says, and
Gray
thank you for Gray Space, member for 4 months. Just reverse on the Cecil search, easy. That's going to be next on our in our next panel. I think there's something there. I think you can turn that into teeth, and in a way that it cannot be considered reversible error. I mean, that it cannot be considered harmless error.
I think you're right about that. Maybe the problem again is the confessions.
Yeah.
I think, even though they got in and the other evidence didn't get in, can the court consider outside of what was admitted at trial, but is in the trial record, that they aren't going to give that much weight to the confessions because of all these other things that, even though it wasn't can they do that?
They were admitted. I mean, yeah, they can certainly say that the confessions weren't. I mean, I think they could only do what's in the trial record. That's an interesting question. I don't have a definitive answer for it.
We can think about it between now and the next, because I'm sure they could find that same excuse in the trial record. There was enough that got in, but just not all of it.
Honey, I'll handle putting them up.
Sorry, babe.
I think one thing I want to say for the audience is, for those of you who were around at the time when I sort of wasn't going to go with anything the state said about the conditions that Rick was being kept in. The only thing lawyers have is credibility with the courts, and I absolutely would have not tried to be too cute about the situation Rick was kept in. The film's there. I mean, I don't care what Gallipo said. I don't. And the same goes. I know we'll get to the Glossop thing, but you can't cite more or less the correct standard for harmlessness at one point, and then at the top, and then say, well, but even if it's there, it was harmless. No. They don't do that with the confessions. They never argue that the confessions, if they were wrongly admitted, were harmless.
Yeah.
But they do that with the Glossop thing. I mean, that's a huge mistake.
Yeah, I mean, it's obviously not anything that the appellate court would be worrying themselves about. But, the one juror that did speak, for whatever weight you want to give her, she said that the confessions didn't really matter to her.
Right.
Yeah,
thankfully,
she said the van was a big deal.
Yeah. And in Rick's eyes, Rick's crazy eyes like that, Rick, he looked over there. He had crazy eyes. I just couldn't get over his crazy eyes. And Brad scared her.
Wait, you
Some of
didn't
those
read Jessica's?
Oh, Oh yeah, Jessica had said, and thank you very much. The AG did tweet about the brief, though. Yes, I saw that. Saw that. And thank you, MBW triple or 007. So she gifted 5 DD podcast memberships. We
Thank
thank
you.
you for that. And then finally, Kat Randall, member for 6 months. Thank you. The best. Thank you for being a member. And then we did get a Venmo from our daily Venmo angel, Kim. Thank you very much
Aw.
for your $25.
Thanks,
We
Kim.
appreciate you.
And
So,
you
all right,
guys think
that'll
about some
wrap it.
questions between now and the next time on the second half of the brief, and we'll, happily dive into them.
Yeah, and Michael, thank you so much for joining us. I know that was challenging wearing the white hat, but I cannot wait to see how you're going to argue against your own. It's gonna that's going to be appointment streaming. Seeing how the man who drafted the motion to correct errors is going to argue that it's a big plate of hot garbage. I can't wait for it. It's going to be amazing.
It's not a big. It's not arguing that, but I mean, when I'm working on almost anything, I'm always thinking of what the other side's going to say. I mean,
You have to.
Yeah.
You have to. I mean, that's how you do the damn thing. All right. You are a gentleman and a scholar, as always, my friend. We really appreciate you. I'll try to give you a little more heads up when we're going to do part 2. I'd like to get it done sooner rather than later. But thank you a million times over, Michael.
well, thank you all for the opportunity. It was absolutely fun, and anytime I get to, it sharpens me up to go up against the likes of Allie and Andrea.
You bet it does.
All
You
right.
bet it does. All right, Michael. We'll talk to you. We're
Talk
gonna
to you.
wrap
Bye.
it.
Thanks.
Bye. All right.
All
Thank
right.
the people, babe.
Okay, well, first I want to thank our mods. I'm sure it was somewhat challenging tonight, as it always is when we have an Alan live. We like to keep it lively in here, but I hope that I was able to achieve what I was hoping to accomplish, was to show that this isn't an echo chamber over here. I wanted to have both sides get aired out. I wanted to hear some really brilliant attorneys argue them out a bit, flesh some of these issues out for us. I hope we were able to achieve that. We still have 2 more big juicy issues to go, and there's a lot more questions to be had, so hopefully you guys will join us for that. I'll try to get that thing set up a couple of days in advance to give you guys notice. So thank you, mods, for all your incredible hard work. We appreciate it every single live. And as a reminder, I'm sure Tracy told you we're going to be having a little mod Zoom tomorrow to discuss a few things, so I'm excited about that. So hopefully you guys can make it over there. We'd really appreciate you being there. And to you guys are beautiful, beautiful humans that are there day in, day out. If you're new, if you're old, it matters not. We adore all of you. We are so thankful for the community because you guys are the best in the business. And just remember this, always and forever. Without you guys, I'd just be an old man.
Sitting around talking to his wife.
True story. See ya.